There were certain things I could not smell themselves, like hazelnut coffee. I'm horrible. I couldn't walk in Walmart. I can't do it. I know. So it makes you nauseous? Yeah. Oh yeah. That's weird. Yeah.
Everybody know everything is
I haven't said anything.
If I could have everybody take your seats, we're going to get started in just about 2 minutes.
Are we ready for me? Not ready.
No, we'll wait till AG gets here.
Just asking. Yeah. This is unique. All good. Great.
Oh, okay. No, okay.
I got your feet. I got maybe 25 seconds.
What's up?
Hi, how are you? Hi. Oh, thanks for having us.
Oh, sorry, General.
Yeah, nice to meet you. Thanks for having us. It's a nice facility. And it's convenient. Have you used it for other crates?
Oh, yeah. Right here. Folks, if you could start taking your seats, I'd appreciate it. Before we get started. Hi, everyone, if you could start taking your seats, we'd appreciate that.
Good afternoon, everyone. My name is Paul Ominski, and I'm the Assistant Vice President for Public Safety at Princeton University. I want to welcome you to Princeton for this important program about the new extreme risk protection orders featuring Mercer County Prosecutor Angelo Onofri and Attorney General Grewal. I've known and worked with Prosecutor Onofri for almost 10 years. Prosecutor Onofri cares deeply about police professionalism and community safety. He has worked tirelessly to foster relationships within the community and to provide community education. He is a key advocate for change in laws to protect the public in order to make Mercer County a safer place to live and work. It's my pleasure to introduce Mercer County Prosecutor Angelo Onofri.
Good afternoon, everyone, and welcome. First, let's give a round of applause to Paul and the Princeton University staff for accommodating us today. Just like to take a moment to recognize three fellow county prosecutors who are in the office. Prosecutor Francis Koch, who's the president of the Prosecutors Association from Sussex County, Fred Knapp from Morris County, and Chris Kubright from Middlesex County. So welcome to Mercer. It's our pleasure really to co-host this event today with the Attorney General's office, and how privileged we are to have Attorney General Grewal here. The Extreme Risk Protective Order went into effect on September 1st, and it really is going to give a lot of protections for people, and particularly from keeping the guns away from people who shouldn't have them because of a crisis or something that they're going through. We've already had our first Extreme Risk Protective Order here in Mercer County. Happy to report everything went very smoothly with that, and it was really a credit to the law enforcement officers who handled that. It is now my pleasure to introduce the 61st Attorney General of the state of New Jersey, Grewal Grewal. And General, as a little welcome to Mercer, the Mercer County Chiefs of Police would like me to give you this challenge coin.
Oh, thank you. Thank you very much.
Attorney General Grewal Grewal.
Thank you, Angelo, and thank you to the Mercer County Chiefs Association for the coin. And I want to thank all of you for coming out this afternoon. I want to thank all the advocates who are here in the room. I want to thank the county prosecutors who have taken time out of their schedules to come from far and wide for this training. I want to thank, importantly, also the men and women of law enforcement who are here to attend this training with you, with stakeholders, because I think by having so many different groups in the room, we also achieve a different purpose, which is getting to know each other and building trust between law enforcement and community and building contacts between stakeholders and law enforcement. So in the events of crises, we're not learning to meet each other for the first time. Ted Stevens, the great prosecutor from Essex County as well, thank you for attending. And in particular, before we get to the meat of today's program, I also want to thank the men and women from our Division of Criminal Justice who played an incredible role in this effort. Jennifer Stonerod, Claudia Dimitro, Sarah Quigley, Jeff Burrill, Jill Mayer, the director of our Division of Criminal Justice, Veronica Allende. I don't know if she's here or coming later. They did extraordinary work in putting this directive together. And the directive really complements what we've been doing in this state over the last 20 months when it comes to gun violence. Combating gun violence is one of our core priorities at the Attorney General's office. And we've taken a new approach when it comes to addressing this issue. We've drawn from the playbook that we used when it comes to the opioid crisis. And that is to treat gun violence as we treat the opioid epidemic, to be a public health crisis. And from that playbook, we're focusing on three things. We're focusing on prevention, we're focusing on treatment, and we're focusing on enforcement. When it comes to prevention, we're working with people like Bill Kastner, who's in the room, and our legislators and our governor to make sure we have the tools to make sure that individuals who should not possess firearms don't obtain them, that we have strong laws and strong background check mechanisms in place to root out those individuals that simply should not have a firearm. And if you go through that rigorous process, yes, you can get a firearm in this state. We are not violating Second Amendment rights. We are just enabling reasonable measures to promote public safety and to make sure that we are keeping firearms out of the hands of individuals who shouldn't have them. When it comes to treatment, we have a whole new playbook in that regard as well. We're focusing on addressing underlying issues of violence. We're investing in violence interruption programs. We're investing in hospital-based violence interruption programs. We're trying to invest in community programs, like our Police Athletic League program in Atlantic City, where we're taking at-risk youth and partnering them with police trainers and boxing coaches to give individuals an outlet, young people an outlet to deal with the crises that they might be having at home or with other students or with other neighbors, and to give them alternatives to violence. And it's my hope that that program can be replicated across the state by giving those young people who might not have the same sort of support network at home that you and I might have had when we were growing up, an opportunity to be mentored and given tools to cope with conflict. And so that's treatment. And that's an example of what we're doing across the state. Enforcement. We're a law enforcement agency. We are out there each and every day dismantling those organizations that are bringing ghost guns into our state, that are fueling gang violence by using firearms in Trenton and in trafficking in firearms in Camden and in our other major cities. That's a core part of what we have been doing and will continue to do at the Attorney General's office. But enforcement also means using the new tools that we've received from our legislators and our governor to go after ghost gun manufacturers and the manufacturers of other firearms and ammunition clips that should not be lawful in this state or are no longer lawful in this state. As soon as we got those tools, we went after large capacity magazine sellers who were advertising online in our state, buying from them through our undercover investigations 100-round large capacity magazines, the same type of LCM that was used in the Dayton shooting. And guess what? We used our tools and we shut down that company from operating in this state. And so we'll continue to use whatever tools that we receive to stop individuals who should not be receiving guns or being able to buy guns from getting them. Because when you go online to these manufacturers and these sellers, they're not going through a background check process when they're giving you the component parts to build your own gun. They're not going through a background check process when they're selling large capacity magazines into the state. And so we want to have a handle on that, and with these new tools, we are doing just that. And with Airpo, our Extreme Risk Protective Order, that's yet another tool for us to make sure that individuals who pose a significant danger to themselves or to others don't have access to firearms or can't purchase them. This is for public safety and it's for law enforcement safety. This is a tool that we've never had in the state. We had domestic violence restraining orders and other types of protective orders, but we never had the ability to say that this individual, as Angelo said, is going through a crisis. And perhaps there should be a mechanism where we can go to a court and we can say, Judge, by making the requisite proofs and going through the process, and I'll leave that to the trainers who will walk you through how this process works, but to show that this individual poses a danger to themselves or to others, and they have access to firearms, and we need to get those firearms out of the house or make it impossible for them to purchase new firearms. And as Angelo said, it's working. It's working in Mercer County. It's working in our other counties where there have been temporary TERPOs or ERPOs. You know, you'll learn the language today during your training, but they have been issued. And so we will continue to use these tools to make sure that our communities are safe, that law enforcement safety is a priority. And again, it doesn't happen, it doesn't work without each of you coming to this training, because this tool is only good if people know about it. And so community engagement has to be a cornerstone of what we're doing when it comes to the Airpo. People need to know that there is this recourse out there for them, that if they're in a dangerous situation. And so you have to help us get the word out there that Airpos are available for individuals and that this is the process that you have to go through. And with this training, I hope that you could bring it back to your communities and to individuals who might be in danger, again, so we could promote public safety. So I want to thank our trainers for being here. I want to thank each of you for attending. I want to thank Prosecutor Onofri for his partnership in this effort. And once again, thank you very much.
Thank you so much, General. Good afternoon, distinguished guests. I'm Assistant Attorney General Jennifer Stonerod and Chief of Staff of the New Jersey Division of Criminal Justice. I am proud to be here today representing the division in collaboration with the Attorney General and Mercer County Prosecutor's Office to provide all of you important information on this important new law. And we thank Princeton University for providing this great facility. When the Extreme Risk Protective Order Act went into effect on September 1st, our state positioned itself to better prevent tragedy. We know that there have been casualties and tragedies, small and large, throughout our country that could potentially have been prevented had legislation such as this been in place. This new law, paired with the Attorney General's directive, provides a tool, as the Attorney General mentioned, that will help make our communities and our citizens safe. That is why I'm proud to be here today. Throughout the month of August, members of the division partnered with the Administrative Office of the Courts to train law enforcement on this new law and the directives issued by both agencies. Today, we are bringing you a portion of that training so you, the public, understand what this law means and how it will be implemented in the state. I am joined by two attorneys from our division, Deputy Bureau Chief Jeff Ferrell from the Prosecutor Supervision and Training Bureau, and Special Assistant to the Director Claudia Dimitro, who provide all of you the information you need to better understand what is an Airpo, as we call it, and how it can make a difference. After the training, there will be time for questions so we can address your concerns. We thank you for joining us today on this important issue. I will now yield the floor to Deputy Chief Jeff Ferrell.
Good afternoon, everyone. Like Jen said, my name's Jeff Ferrell, and let's just get started right now. So a lot of the terms that you're going to hear during our presentation, and that's usually used when there's a dialogue that's occurring about these extreme risk protective orders, I'm going to cover so everyone's on the same page. Airpo, that's the extreme risk protective order. Everyone's used that already. But when you think of Airpos, you can really break them down into two classes. We have the temporary extreme risk protective order, that's the TERPO, and the FERPO. I did not come up with these names. So the FERPO, which is the final extreme risk protective order. And during our presentation, we're going to talk about what each one of those is and how they work. Law enforcement officer is LEO. We commonly use that abbreviation. Same with LEA. It's the law enforcement agency. I know we're dealing with rocket science here, and I'm glad we're at Princeton so everyone can understand this material. We're going to use the terms petitioner and respondent in the context of Airpos. And that's because those are typically terms reserved for a civil process. And although these petitions are heard by the criminal division of the Superior Court, it is still a civil process. So petitioner is going to be an eligible class of people that can file one of these against the respondent. And we're going to go over who that eligible class is in a few slides. CPO is going to be the county prosecutor's offices throughout our state. We have 21 of them. And DCJ is going to be the Division of Criminal Justice. That is a division within the Attorney General's office. So oftentimes those terms are used interchangeably. Now, Airpo went into effect in New Jersey on September 1st. And what that does is it basically allows an eligible petitioner to apply for a TURPO against a respondent who presents, and you're going to hear this phrase over and over again, and I just may start calling it the Airpo standard, but is someone who presents an immediate and present danger of causing bodily injury to themselves or others by possessing or purchasing a firearm. Now, I just want to pause here for one moment. This is not a political presentation, but many of you may have heard Airpos discussed in the national context, either referred to as Airpos themselves or red flag laws. And one thing that has been a lot in the public discourse on this is that everyone hopes that this tool will prevent the next mass shooting. I 100% hope that that is the case, but one interesting thing that doesn't usually get talked about, but there's really interesting data behind it, is that this is a phenomenally effective tool against someone causing injury to themselves with a firearm. Claudia and I had the opportunity to liaise with other states and their law enforcement agencies that work on these issues throughout the country. And during that meeting, I had the privilege of meeting with a professor from Duke University who had a really compelling piece of data that he wanted to share with everyone. And he was able to analyze jurisdictions that enacted Airpos and red flag laws. And he was able to distill out, without any crazy manipulation of data, that roughly for every 10 to 20 of these petitions that are filed and issued, it correlates directly to one life being saved. And that blew my mind away. As a member of the law enforcement community, I know one thing that law enforcement wants to do, regardless of political persuasion, is to protect the public. And when we know that we have a tool that's that effective, I think it's something that everyone in the law enforcement community can get behind. So I just really wanted to flag that and discuss that because I thought it was fascinating. So back to the Airpo Act. So once this petitioner applies and fills out the petition and submits it to the court, they are entitled to an expedited hearing. Now, normally within court rules, there's set times for things to happen and very specific definitions. That's not the case here because I think everyone wants to be on the same page that expedited means quickly. So there's no set time frame where, within 6 hours, because sometimes these are being heard 20 minutes after the petition gets submitted and the judge gets called to hear this. So everyone, all of our law enforcement partners that we have worked with is on the same page that this is going to be quick. So once that hearing takes place, and assuming the TURPO is granted, the law calls for a final hearing to be scheduled. And that final hearing is going to be scheduled 10 days out. Now, once a TURPO issues, and similarly, once a FERPO issues, there's certain protections that go into place and certain prohibitions. Specifically, that respondent is prohibited from possessing or purchasing a firearm or ammunition, and also from holding any firearms identification card. So there's the firearm purchaser permit in New Jersey, there's handgun purchaser permits, there's permits to carry. So all of those are suspended, they need to be turned in. And additionally, there is in the law basically a contemplation to have a search warrant issue when that TURPO or FERPO issues, and that will allow officers to go in and seize weapons. And we'll talk very briefly about legal standards in the search warrants in a moment. And the other thing that the TURPO or the FERPO gets us when it is issued is that person, so the respondent, becomes a certain person. Now, for the general public, and Claudia and I have given this training along with the courts to over 2,000 law enforcement officers in the state, and all of them are familiar with the term certain person. But there is a law in the criminal code that prevents someone who meets a certain class of, just a certain class of things where they are not allowed to have a firearm. And if they do have a firearm or they're found with one, there's enhanced penalties against them. So by someone who has a TERPO or FERPO issued against them, they are now moved into that category of a certain person not to possess firearms. All right. I'm going to talk briefly about the search warrant. The way the statute's written, it really models the Domestic Violence Act. And lots of people and lots of law enforcement officers are very familiar with the DV Act, so you're going to hear a lot of comparisons between Airpo and the DV Act. In the DV Act, up until the end of August, basically, or no, I'm sorry, the end of July, there was a standard that law enforcement officers could use if a temporary restraining order or a final restraining order entered against a respondent to go ahead and go search for weapons so that that person does not have weapons. And that legal standard was reasonable cause. When the Airpo Act was enacted, the law basically contemplated that a search warrant would issue if a TERPO issues. Now, the way the law is written is if there is good cause, a TERPO should issue. So our New Jersey Supreme Court in the State versus Hemingway case looked at just the DV Act and said reasonable cause, while good and there's due process there, is not probable cause. And our standard for issuing a search warrant is probable cause. So what we're able to do when the Supreme Court changed the standard in the DV context is we preemptively got ahead of it with the courts. The Attorney General issued in their directive saying, hey, you will not get a search warrant unless you establish probable cause for these weapons. So while a TERPO or FERPO, while a TERPO can still issue if there's good cause, we're not going to get a search warrant unless there's probable cause. So that'll come up throughout the course of this presentation, and I just wanted to give that very brief legal explanation to everyone here. Now, I've referenced the Attorney General's directive and the court's directive. And basically, we have directives for law enforcement officers in the state, and the court has directives for attorneys practicing in the state and the judges of how these should be handled. So for those of you that are interested, the AG Directive is listed on the Attorney General's website. It's 2019-2. And similarly, the court's directive is listed on their website. Now, everyone has a copy, a paper printout of this PowerPoint presentation. If for some reason you did not get one, see either me or Claudia. We have extras, but the websites for these are listed there. One thing that I wanted to point out about the Attorney General's directive that I think is really great is all the other states that have the Airpo Act or its equivalent, they roll out training, and there's a lot of discretion left to each agency with how they handle these. In New Jersey, our Attorney General said, you know what I want to do? I want to make sure that this is handled consistently and uniformly throughout the state. So he decided to issue a directive. And I think that's a great tool that our law enforcement has because they have something that they can easily reference when they're dealing with these situations, and it gives a roadmap of how they handle them. So that is something that is unique to New Jersey. Okay, the Attorney General mentioned this in his comments, and Claudia and I have certainly mentioned it throughout our presentations to law enforcement. Airpo works if people know about it. So what the Attorney General's directive calls for is telling people about it, informing the public. So what our directive says is when a law enforcement officer encounters a petitioner who is concerned about a respondent who meets that Airpo standard, right, the immediate and present danger of causing bodily injury to themselves or others, then that law enforcement officer needs to inform that potential petitioner about the Airpo Act, the procedures, who qualifies as a petitioner, and what they need to do to file one of those. So, like the Attorney General called upon all of you, I'm requesting the same thing. Please spread the word about this. The reason that's important is, again, with networking with other states, what we've seen is in some jurisdictions, when Airpo goes live and those red flag laws go into effect, there's almost no filings. In companion states, there's a ton of filings at the beginning, and then they drop down to nothing. So these two charts are almost complete opposite. They start out at nothing, and as public information gets out there, the filing numbers go up. And in other states, they make a big effort at the beginning to tell everyone about it, and then they just stop, and the numbers go down. So please spread the word about Airpo.
Jeff, do you want questions at the end, or?
Questions at the end would be great. We do cover a lot of material in this training, so Claudia and I love answering questions. We just ask you to hold it for the end because we do have a lot of material in here. But thank you. Now, I've mentioned the DV Act, and I know the Attorney General mentioned it in his comments. One thing that we are doing with law enforcement community is saying, hey, Airpo is a new tool in your toolbox. Do not ignore the rest of your toolbox. So there's going to be situations where requesting that someone file and try to get a TERPO issued against a respondent is the best situation. There's going to be others where TERPO may not be the best tool and you want to go for the DV restraining order. And there's going to be situations where both are appropriate. So what we want to message out to everyone is that as an added tool, you don't forget what else is in your toolbox. So we do tell law enforcement officers to go over everything. And here's kind of a quick comparison of the intent and the eligible petitioners in the DV world and also the Airpo world. So in DV world, there is a set amount of people who can file for one. And it's a general category of family or household member. And in my next slide, I'll go over and unpack that term a little bit. With the DV Act, you need to have a predicate act of domestic violence before you can go and get one. And the whole intent and purpose of the DV Act is to protect the victim in that situation. Now, in the Airpo world, we have a similar class of people. We have family and household members, but we're adding a very important tool and a very important class of eligible petitioners to this, and that's law enforcement officers. And we'll talk about their role in these in a few slides. The other great thing about Airpo is there is no predicate criminal act required. Now, there could be situations where there is a predicate criminal act where there's a crime committed and someone believes that one of these TERPOs should file. That doesn't stop them if that crime is there. I think the benefit is no criminal act is required. And as we were talking about, this is a public safety tool designed not to protect just the victim in a situation, but to protect the public and that particular individual from someone who poses that Airpo standard, right? The immediate and present danger of causing bodily injury. So unpacking that family and household member, so that can be a current or former spouse. It can be a present or former household member. It can be a current or former dating partner. And it's someone that you have a child in common with or are expecting a child in common with. And then the big class of law enforcement officers. So we get a lot of questions, and just times being what they are, sometimes you can have a best friend in your life that knows everything about you. They've been friends with you since you've been a little kid, and they go to law enforcement and they say, I've known this person 35 years and I am concerned because of this. I want to file one of these Airpos. Well, if they don't meet the eligible class, they can't. And even if that friend says, you know what, I know them better than their own mom because mom's only been in the picture for 10 years. Doesn't matter. The eligible class of people is listed by statute, and that's what we have to follow. Like I said, the respondent's the person that the Airpo is being filed against. And one thing that we do get a lot of questions about, because here's another difference between the DV Act, is the respondent in the Airpo world can be a juvenile. So I just wanted to highlight that for everyone. Now, New Jersey does have special rules if the potential respondent is a law enforcement officer. And Claudia is going to talk about those situations in her portion of the presentation. Now, when you want to submit this petition that we've been talking about, you have a couple places that you can do that. Be it the Superior Court, that's with the criminal division, like I mentioned earlier, or it can be with a state, county, or municipal law enforcement agency. Again, different rules if the potential respondent is a law enforcement officer. But now here's what we're doing in New Jersey. We have an electronic complaint system in New Jersey, and to access that system, you have to either be an attorney, member of court staff, or a law enforcement officer. So it can only be entered by those people. The average citizen can't do that. So when you go to one of these places that I talked about, there's going to be a law enforcement agency that's going to process this and submit it. Based on the court directive, and this models and follows and complies with both the Airpo Act, but also the technological limitations that the court has, is this petition needs to be submitted to the court where the respondent lives. So that is one thing that we come up and have a lot of hypothetical questions about. Well, what if, right now we're in Mercer County, and you have an ex-spouse that you're concerned about, you speak to them often, they're having suicidal ideations, and they're escalating and they're talking about using a firearm to take their own life. So you go to your Princeton Police Department, and the officer there says, okay, you live in Mercer County, where does the respondent live? Well, the respondent lives in Cumberland County, and in Bridgeton, let's say. So what our directive spells out, and what we need to do, is that law enforcement agency here in Princeton needs to call their law enforcement counterpart in Bridgeton and say, hey, I have a petitioner here who wants to file a TERPO, and kind of connect those people so that application can be done over the phone. So I just want to highlight that in case there's any concerns or questions that arise with where this needs to be done. So like I said, our directive requires law enforcement to tell people that have concern that someone meets the Airpo standard about the petition, also because it's in that electronic format that only law enforcement and court staff have access to. That law enforcement agency needs to, or that law enforcement officer needs to put on their data entry hat and start entering the fields on behalf of that petitioner that's in front of them. And if the situation calls for it, the directive gives discretion to the law enforcement officers to ask and try to cull out additional information from that person that's in front of them. Law enforcement officers in our state are phenomenal. They have a great wealth of training and experience. And if they see a pattern unraveling in front of them where they know that, oh, factors A, B, and C are in front of me, and based on my training experience and the facts of this case, I know X, Y, and Z are going to be probably around, they can go ahead and tease out that additional information if they think the situation calls for it. So that's another great feature of our directive. All right, we've spent a lot of time talking about what Airpo is, the petition process, and where we file it, but what needs to be in this petition? So there needs to be the allegation that this potential respondent poses the Airpo standard, okay? And beyond just the allegation, it has to set forth how that person knows that this danger is present. So the facts, the basis for their knowledge, details the relationship, anything that gets us to how we know this information. Additionally, it has to set forth the concern about firearms, if firearms are present. So number, types, physical description, things that you would expect that someone who has a concern about this situation would have information about. It can also reference external documents. A common example that we anticipate happening and have seen in a few of these petitions already is Facebook posts. So social media printouts. In that petition, you can reference, I have a concern about these posts that are this in nature, and it can reference that and include those as almost an exhibit to the petition. And most importantly, it needs to be sworn and submitted under oath to the court. Also, as with any official document in New Jersey, if it is submitted under oath, there is anyone who submits an official document under oath is subject to punishment. So that added feature in there, I think, help weeds out any sort of malicious or frivolous petitioner who's seeking to simply file one of these to hurt someone instead of them having the legitimate concern that the respondent meets that Airpo standard. So I mentioned there's a class, law enforcement officers are eligible petitioners, and we just very briefly anticipate that their involvement can occur in one of three ways. They can file the petition on their own. So based on the course of their day-to-day duties, they encounter someone that they believe meets the Airpo standard. and they have probable cause to believe that that person meets the Airpo standard, our directive requires them to file one of these petitions against that potential respondent. Taking over, so an otherwise eligible petitioner comes in, speaks to a law enforcement officer and says, hey, I know someone that I believe an Airpo should be filed against, and in speaking to them and in learning more about the information of the case, that law enforcement officer believes that it's going to be in the best interest of everyone involved that that law enforcement officer becomes the petitioner and excludes the otherwise eligible petitioner in that case. And the way we see that potentially happening is if a eligible petitioner comes in and they're going to be out of the country for an extended period of time, they're about to go in for surgery, and they're going to be unavailable to do anything for the next couple of weeks, and we still have this immediate and present situation in front of us, the law enforcement officer can take that over, and if there's probable cause to believe that that Airpo standard's met, our directive requires the law enforcement officer to take it over. And then there's also a situation where law enforcement can join in. The courts have created an identification tab within their petition that allows an eligible petitioner to file one of these, and also, if the situation is right, for a law enforcement officer to join in and say, in addition to this petitioner, I'm going to be one as well. So that's how we envision that working out. So I did mention probable cause a couple times. Like I said, our directive requires law enforcement to be involved if probable cause that the respondent meets that Airpo standard exists. If there's anything less than probable cause, but they still meet the statutory good cause standard, they have the discretion to be involved and file one. Now, like I said, the Turpo, when one issues, it needs to be heard in an expedited manner. During that hearing process, like any other court proceeding, it's going to be recorded in one way or another. The judiciary anticipates that a lot of these are going to be recorded. There's going to be audio recording of it. If the facts don't call for it, there can be extensive notes taken on that petition. The venue, it's ultimately going to be heard where the respondent resides. Here's one thing that we haven't seen yet, but anticipate could be an issue. If the respondent lives out of state, but the petitioner lives in the state, then it's going to be where the petitioner lives. And that's just logistics that we're working out. If this hearing occurs during normal court hours, so 8:30 to 4:30, Monday through Friday, non-holidays, then that hearing is going to be done by a superior court judge. If it's after hours, then it's going to be a municipal judge. And the contents of that petition, when it gets in front of the judge can kind of intake that information in the law calls for one of three ways, but really boils down to one of two main ways. They can rely on a sworn affidavit written and have no further questions that they ask, or they can conduct examination of that petitioner and take sworn testimony from them about the Airpo factors. We're going to go over the Airpo factors in just a minute. And at this temporary hearing, we don't anticipate the respondent being involved. The law doesn't call for it. The respondent has the opportunity to be involved at the final hearing. Claudia is going to talk about that. But at this urgent, emergent, and quick-paced hearing, it's just going to be the petitioner, potentially law enforcement, and the judge. The court, after they get all this information, are going to kind of try to plug all the facts they have and see what Airpo factors they meet. I'm going to talk about that in the next slide. And before we get to those, I want to remind everyone that the legal standard, as enacted by the legislature, is good cause that the respondent meets this Airpo standard. If good cause is there, the Turpo can issue. The search warrant's going to issue if we have more than good cause, but we meet that probable cause standard. All right, here are the Airpo factors. The first one is whether that respondent has a history of threats or acts of violence that's directed towards themselves or others. The second one is whether that respondent has a history of use, attempted use, or threatened use of physical force against another person. Whether they have been the subject of or have previously violated a final or temporary restraining order that was issued under the DV Act. Number four, Similarly, but whether they have been the subject of, have violated a temporary or final protective order that's issued under the Sexual Assault Survivor Protection Act. It's commonly referred to as SASPA. Whether that respondent has any prior arrests, and this is one we highlight to law enforcement officers, pending charges for, or convictions for a violent indictable crime, disorderly persons offense, a stalking offense, or any of the domestic violence offenses. Similarly, whether that person has any prior arrests, pending charges, or convictions for any offenses involving cruelty to animals or acts involving cruelty to animals, whether they have a history of drug or alcohol abuse and what their history of recovery is from that abuse, and whether they've recently acquired a firearm, ammunition, or other deadly weapon. Now, I want to pause here very briefly for one moment. These 8 standards are the standards that are written into the law. The judiciary and taking the advice from the Criminal Practice Committee of the Supreme Court has added some additional factors that are completely appropriate to this situation because they come into play in other firearms laws that we have. So these are factors the court already considers and prosecutors and law enforcement already consider when it comes to the firearm universe, and also some that just logically make sense because they model the DV Act. And those are whether that respondent has recklessly used, displayed, or brandished a firearm, whether they are the subject of an existing or a previous Airpo. And again, that can mean temporary or final. And so with those factors, if the court finds any one of those factors, the court can then go on to these additional factors that I'm going to cover. Number 12 is whether that respondent has a prior involuntary commitment to a hospital or treatment facility for persons with psychiatric disabilities, whether that respondent has received or is receiving mental health treatment, and really what their compliance with that treatment is. So whether they've complied or failed to comply with that treatment, and whether they have received a diagnosis of mental health disorder. Now, before I turn it over to Claudia, one thing that I want to mention for the benefit of everyone, judges don't have a magical algorithm or formula when it comes to these Airpo factors. A judge can look at one of these factors and find an extraordinary amount of weight on that factor and decide it's appropriate to issue that Airpo. Or the judge can find a little bit of each of 10 factors and say, you know what, I don't have enough to issue one. So for the benefit of everyone here, there's no magic formula. It's in the judge's discretion. So with that, I'd like to turn it over to Claudia. Thank you. Thanks, Al.
Very good. Thank you, Jeff. So I'm just going to continue right along here with our training. So the statute itself gives the county prosecutors and law enforcement the obligation to provide information to the court regarding these Airpo factors that Jeff just went through. So just for you all to know that either the law enforcement agency where the respondent lives or the county prosecutor's office of the county where the respondent lives will provide in an expedited manner any readily available information or evidence, including evidence of the factors to the court for the court to consider. So law enforcement or the prosecutor will give this information to the court so the court can have the benefit of it in determining and weighing the factors that Jeff just went through. Okay, so after the judge signs and finds good cause to issue the Airpo, it has to be served. So that's going to be sent to the law enforcement agency and county prosecutor where the respondent lives. And then that law enforcement agency will serve the Airpo on the respondent immediately or as soon as practicable. If you're someone who's familiar with the DV world, very similar to a TRO being issued, and then the law enforcement agency serving the TRO on the respondent there. So same process would occur. The Airpo and the FERPO, they remain in effect until a further order, okay? So this is something that's very important for everyone in New Jersey to know. Unlike other states, there is no automatic expiration of a Airpo or a FERPO in New Jersey. So If the turpo is issued, and then I'll go on, and then if the final is issued, that final order does not expire automatically. Other red flag laws in other states do have a set time period. Not true in New Jersey. They can be terminated. There is a process for that, and I will go through that process. But very important to know, and there's been some confusion out there, I think, in the media on this, does not automatically expire otherwise. The turpo order, just like a TRO, will tell the respondent of the turpo and will give them notice of the final hearing and where and when to show up for the final. Okay, a search warrant. So, as Jeff sort of previewed, the statute also provides that a search warrant can issue along with the turpo. It's kind of the way the court's directive is laid out. It's sort of the second step in the process. So after the court can then issue the final order. If for some reason there was no search warrant issued at the temporary, either it wasn't requested or the judge denied it, the judge does have the ability after the final to then issue the search warrant there. Okay, so there's the obligation that I told you that law enforcement and prosecutors have to provide information, again, comes up for the final. So the law enforcement agency or county prosecutor will again have this renewed obligation to give information to the judge prior to the final hearing. So they'll do it prior to the temporary and then again prior to the final. And it'll be similar information. Now, law enforcement may have some additional things to give to the court now that the temporary has been issued and the search warrant perhaps has been executed, and they'll give to the court, to the judge, to consider at the final hearing. But again, it's going to be the same factors that this information should be related to. Okay, so special sort of notes on appeals, and this also is good for any of you who practice DV or domestic violence victim advocates. This is a new procedure that impacts both DV and TRPOs, and they mirror each other. So it's a little detailed, but bear with me because it's important, right? So today, if somebody wants to appeal a denial of a TRO, right, a denial of a temporary domestic violence order, what does the person have to do? So if they're being heard by a municipal judge on non-court business hours, and they want to appeal that decision, that denial, what do they have to do? They have to wait to the next business day, and they're told to go to the Superior Courthouse the next business day and apply for a Superior Court judge to hear an appeal of the municipal court denial. Okay, so that's true today for DV. That is changing on October 1st for domestic violence. Starting October 1st, if a municipal court judge denies a TRO application, night, weekends, holidays, and a person wants a Superior Court judge to immediately review that denial, they have the right to an immediate de novo review over the phone to an on-duty emergent Superior Court judge. So again, sticking with DV here in the TRO context, they should, and the municipal judge should explain this to them at the end of their decision, but the law enforcement officer who facilitated the phone call to the municipal judge will hang up the phone with the municipal judge, call the Superior Court judge for the person, the victim filing the restraining order, and then the Superior Court judge will hear the appeal right there. So that's the order from the Administrative Office of the Courts to all of the Superior Court judges to now be on call for DV starting October 1st to hear appeals, okay? So a similar procedure will mirror in the Airpo context. So if a temporary TRPO is denied prior to October 1st, because the statute is in effect today, right? So we have some time period between now and October 1st. If it's a municipal court judge, starting on October 1st, again, just like DV, the petitioner can request immediate review to an on-call Superior Court judge. And like I said, just like DV, the law enforcement officer will call the Superior Court judge for the petitioner in the Airpo context. So on the same date, the switch will go on and the Superior Court judges will be ready to hear immediate de novo appeals in both domestic violence and extreme risk protective orders. Prior to then, in the Airpo context, just like DV, the petitioner will have to wait till the next business day in order to request review by a Superior Court judge if a TRPO is denied. If it's heard by the Superior Court judge first, because as you know, if it's during court business hours, it's heard in the Superior Court, then the petitioner, if it's denied, can file an appeal to the appellate division, like any other appeal. If any petitioners have any questions about how to do that process, there's information at the courthouses, pamphlets, as well as the court's website about how to file an appeal to the appellate division. Likewise, I told you, finals are always heard in Superior Court. So if the final FERPO is granted or denied, whoever is the aggrieved party, whoever wants to appeal, again, can file an appeal to the appellate division. And the courts have more information if they need help on that. But that's not going to be facilitated by the law enforcement officer. Only if it's an immediate appeal from a municipal court, then the law enforcement officer will call up the Superior Court judge for them. Okay, so Jeff alluded to this a few times, I should say. What happens when the respondent happens to be a law enforcement officer, okay? So the statute itself, so this does not come from the Attorney General's directive. The statute itself sets forth a different procedure when the respondent is a New Jersey law enforcement officer. So we have to comply with the statute's procedure. So if a petitioner seeks a TURPO against a New Jersey law enforcement officer respondent, as I said, a different procedure must take place according to the statute. So this is only New Jersey officers, and that's defined in the statute, so it does not apply to federal or out-of-state officers, even if they live here. Someone who is employed as a New Jersey law enforcement officer. One of the most important things, the messages that you can get out to the community, and this is can be tricky, is the statute says that petition against that officer may only be submitted to the agency, the law enforcement agency, where the respondent works. Only there can the petitioner go to ask for a TURPO against the officer. So it's the agency where the respondent works, not where he or she lives or any other agency nearby. Only that single agency where the officer works can the TURPO be filed against him or her. And again, that's straight from the statute itself. So we have to comply with that. The statute starts this, basically requires an IA investigation against that law enforcement officer. So once a petition is given to the agency where the officer lives, that his or her own agency will immediately initiate an IA investigation. The Attorney General directive requires it to be expedited because time is of the essence here in these crisis situations, and they have to get it done in 48 hours, is what the AG Directive tells them. There is the ability for the agency to basically seize all weapons, department and personal, from the officer while this investigation is going on. It does not need to be completed. So the standard in the AG Directive, and it explains it more, says that if the agency has probable cause to believe that the presence of weapons would expose the respondent officer or others to the risk of bodily injury, the agency shall seize all weapons, department and personal, possessed by the respondent. So they do not have to wait till the IA is complete. They can do so if they find the need is there at that moment. Okay, so after the agency completes their IA investigation, a little out of order here, I'll just do them all. They have to send under the AG Directive all the results and conclusion of their investigation within that 48-hour time frame to the county prosecutor office in the county which they're located if they're a local agency. If they're a state agency, it's going to be sent to the Division of Criminal Justice, which is the prosecutors within the Attorney General's office. Okay, so we have the agency IA review, and then you have a prosecutor review of that IA second afterwards. So the prosecutors to have one business day to decide whether to file the TURPO if they find probable cause to believe the danger is present. So the statute, again, mandates a prosecutor review. Just to be clear, that's not part of the directive. The statute says there must be an IA, and the statute says there must be prosecutor review of that IA. The AG's directive tells prosecutors, again, time is of the essence. You have one business day to decide whether to file. The statute ultimately gives the prosecutor the final decision whether to file the TURPO. So this is from the statute. It says that the prosecutor decides whether to refer the TURPO to the court. So no TURPO is actually entered or given to the court until the prosecutor makes the final decision. It's held within the agency and the prosecutor's office up to that point. The first time the court will learn of the TURPO attempting to be filed against the officer will be after the prosecutor makes his or her decision, and so that is why time is of the essence to get these done quickly. So then the prosecutor will become the petitioner in that scenario if they decide to file the petition. And if no, the Attorney General's directive mandates notice to the original petitioner, the original person who requested it, and to the officer. So everybody is told the answer is no. So that the statute gives that final decision to the county prosecutor about whether this should go to the court or not. Storage of firearms, this is something we talk about more with law enforcement, but just so you know, either the law enforcement agency or the county prosecutor's office, depending on the county's policy, will store the firearms and ammunition that are seized from any kind of respondent, whether it's a regular respondent or a law enforcement officer respondent. This is just for everybody. Somebody other than the respondent. So as I told you, the Attorney General's directive takes the position that if the firearms or ammunition happen to be owned by someone else besides the respondent, they still shall be seized by the law enforcement officer if they have a search warrant. But that individual, the person who owns the firearms that is not the respondent, has a mechanism built from the statute itself to request the firearms to be returned to him or her at the law enforcement agency. So the statute itself gives them the ability to request weapons returned to them at the agency, not on the scene, not in the middle of the search warrant. The respondent themselves also can request the ammunition or firearms to be transferred and sold by a licensed dealer. So if the respondent says, you know what, I'm not going to be fighting for my guns anytime soon, I'd just rather have the money, good idea, right? They can request that it be transferred and sold by a licensed dealer. And termination of FERPO. So I told you they do not automatically expire in New Jersey. I again reiterate that, but they can be terminated. So any party, either the petitioner or the respondent, can request and file a petition with the court at any time to terminate the final protection order, right? So they can petition the court for termination at any time. There will be notice from the court to the other party. So if it's a respondent who applied, the petitioner will be notified, and vice versa. There will also be notice to the county prosecutor's office and the law enforcement agency that this request for termination has been filed. There will be a court hearing, right? So the judge will ultimately make the decision at a hearing whether to terminate the final. The AG's directive tells prosecutors and law enforcement that they have the ability to object at the hearings to termination, and if they in deciding whether to do so and how to object, the directive tells law enforcement to consider those original Airpo factors that Jeff went through with you. The statute itself also tells us to consider whether the individual, the respondent, has gotten mental health treatment in the meantime, maybe really cleared up the crisis that he or she was going through treatment. And of course, the directive adds, consider the petitioner's opinion in deciding whether and how to object to termination. If the respondent is the one who requested termination, so if he or she says, I no longer should have a FERPO issued against me, the statute says that there's the standard is preponderance of an evidence, that they no longer pose the significant danger of causing injury of to self or others. So as I told you, preponderance of the evidence is more likely than not, about 51%, right? So if it's the respondent who's asking for it to be terminated, it's his or her burden to show to the court that it's more likely than not true that they no longer possess the danger. Okay, so that the burden is on the respondent when he or she is the person requesting termination. And if the judge agrees and the FERPO is terminated, the respondent can request the firearms and ammunition to be returned to him or her which shall be done within 30 days. The statute says as long as that person is legally allowed to possess a weapon. So, as Jeff said, if certain individuals are not allowed to possess weapons, or as you may know, some weapons in New Jersey are just not allowed to be possessed by anybody. Of course, those weapons are not going to be returned to the respondent. But as long as they are legally allowed to possess the weapons, they will be returned within 30 days. So that's the conclusion of our prepared remarks. And now I open it up, and I invite Jeff to come up with me, or Jen, please. And we're happy to answer any questions that you may have. Yes.
Okay, so I've read it over several times, and I'm still confused about this point. Airpo is to remove guns, right? That's the point of having external.
In addition to other things as well as removing guns.
The purchaser identification card, that's a big one, so that if you take someone's guns, they can't go buy more.
So then why, if an Airpo is issued, why, and the point of it is to get hold of all those pieces, why do you then need a search warrant?
So an officer is not allowed to seize weapons from anybody without a warrant or an exception to the warrant requirement. So that's the Fourth Amendment tells them that in order to seize,
Doesn't cover that?
it does, and that's how they do it through the search warrant. So the Airpo gives the process for the search warrant to seize weapons. Otherwise, there are times where officers have the ability to do it without a warrant, but under the Fourth Amendment, it's a warrant or a warrant exception. So that's just to comply really with the Constitution.
So when you apply for an Airpo, when would it just not issue a search warrant? Because, that's what I don't understand.
Yes, yeah, good question. If there's a danger posed by firearms, but the firearms themselves have not been, again, this comes from the Constitution, particularly described. So if I say, my brother, I'm concerned, he's going through crisis right now, he told me he's going to buy a purchaser ID card, or he's going to buy a weapon, he has the ID card, but I know he doesn't own a weapon now, but I'm still concerned and I want to prevent that from happening, likely a search warrant would not be issued because there has to have been a demonstration of weapons to be seized. But doesn't mean that the Turpo shall probably still be appropriate to prevent those other future acts. Yes.
That kind of follows on with that. So does the petitioner have to be able to describe where the gun is located to state the specificity for the warrant will be issued? So for example, if they come in and say, I've had the respondent say these threats about themselves, I think he keeps his gun in his car. Does that limit the search warrant?
So that's up to the judge to decide, right? And so they'll have that discussion, but the judge will have to make the call about whether that's particularly described. So may not, but may, depending on specific facts and the judge.
Yeah. One thing we find it's really difficult to deal with, like a just one sentence factual situation in the hypothetical, because the judge has a whole host of other facts to consider as well, so they consider the totality of the circumstances.
Could be either way.
If there's not probable cause to issue a search warrant, is there a mechanism to get consent to search?
Yes, and the statute does provide that the orders respondent to surrender the weapons at the temporary, once it's being issued against the respondent. But if he says or she says no, then the officers are limited there, but they can surrender without a search warrant.
And I'm glad you brought that up, because one thing that we didn't cover in our presentation, which is usually more law enforcement based, is there's something in New Jersey called the duty to warn. And pre-Airpo, whenever a healthcare practitioner raised a concern about one of their patients, that they thought their patient presented an immediate and present danger of harming themselves or someone else, they have a duty to tell the chief of police in that jurisdiction. Chief gets this notification, and they're without a tool to go into the house unless they have one of the other exceptions, unless they have information that the weapon that the respondent has or this patient had is an illegal weapon, so they can get a search warrant under one of our criminal codes. So a lot of times they were relying on consent. They say, hey, we're from the police department, we have this duty to warn notification, we're concerned. While you're going through whatever you're going through, we'll store your weapons for you. And a lot of times, good old-fashioned police work like that was successful. But there's other times where that person says, officer, thank you, I appreciate it, I'm good, my doctor's prone to hysterics, and they just close the door on that officer's face. So the Turpo, the Furpo is a really great tool to have to respond to those situations as well.
Yes.
I have two questions. One is in relation to representation. So are CEOs going to be providing representation to family or household members who are requesting this on their own account?
No.
Also law enforcement officers?
So County Prosecutor's Office, under the AG's directive, will be present if it's a law enforcement officer petition,
So they'll be pro se litigation?
just like in domestic violence.
Okay.
Yes.
And then my second question is in relation to the remedy. Will the remedy for a violation of the Airpo mirror the PDPA?
So there is two things, as Jeff said there, become a certain person, and that's amended. Also, I think what you're referring to, the contempt statute, that there's a separate provision for the PDVA. There's also an additional amendment for Airpo. So if someone violates the order, they are in contempt of a court order, just like any other court order, and there's a specific provision for this, just similar to PDVA.
So like some violations of the PDPA warrant a new criminal charge as well? Will this have criminal penalties?
So this is a contempt of court, yep, under 2C, a separate criminal charge.
Yeah, under 2C29, that section contains the contempt, and it's a fourth-degree indictable level conviction or crime in New Jersey. So, sorry.
Yes.
In terms of the storage, if someone other than the respondent claims title to some of the weapons and wants them back, is there any kind of requirement that there's
Yeah.
safe storage shown so that the person can
So each county prosecutor's office is addressing this differently, and they all have different policies and procedures that they're telling their law enforcement officers. And to really answer your question, some are requiring more before it can be returned. Yes.
To piggyback on that, if those weapons then that have been claimed, not the respondent's weapons, but somebody else claims them as their own, if they're then used by the respondent to carry out an act of violence against themselves or others, is that now person liable?
Yes, so they violated the court order under 29-9 and are subject to new criminal charges.
Well, that, just
Yeah.
to clarify on that, the respondent
Yeah.
has that added one. I think you were talking about
sorry.
the lawful owner of the firearms. I think it all depends, and, you know, I hate to use that as an answer for a lot of these situations, but law enforcement will do what they can to investigate, to see the facts of the situation, to see how that respondent got access to those same weapons again. So we don't have a bright line answer. The way the Airpo Act is written right now, there is not an addition to our criminal statute that has liability for that legal owner through Airpo. But there are other tools that law enforcement has, if appropriate, they would use.
There was one over here. Yes.
Hi, I'm the director of the Psychiatric Crisis Center for Mercer County. Do I have to report to local law enforcement every person that comes in that has a risk factor? Because that would be like 6,000 people.
No, and if they meet the Airpo standard, right, there needs to be a nexus to firearms. So we've heard from healthcare practitioners that sometimes someone comes in and there's no relationship to firearms. This person just wants to harm themselves, and they're talking about maybe hanging themselves or something else that's not connected to firearms. So
Yeah.
I think
But even if they have a firearm, the statute does not put any obligation to you besides under duty to warn.
yeah, you still have to comply with your
But
duty to warn.
Airpo does
standard, yeah.
not for civilians. It's really the AG directive gives this obligation to law enforcement only.
Is there an appeal process for when the respondent is a law enforcement officer?
Good question. No, not the statute doesn't provide for, and because under the statute it cannot be referred to the court if the county prosecutor says no. So I don't know, that may change in the future, but right now, no appeal process. Yes.
So, we went through this quickly. So, if the law enforcement officer is the respondent, okay, so then it goes to his or her agency. At that time, then, that person is made aware that there is an investigation on him. Is that correct?
That I would defer to the agencies. Whatever rules they have. I don't know about notice to the officer. You're saying whether that officer is notified. it depends on what their agency protocols and IA procedures are. I don't,
Because doesn't that then put the potential petitioner
yes.
in a risky position?
I understand your concern. I don't want to speak for the agencies about whatever. I mean, and these type of things are being filed in the domestic violence realm. Other, concerns about officers, and I imagine they would follow similar procedures they were doing before September 1st to today.
Yes.
I work with DV victims, so that's kind of where my scope is right now. So when I heard that, piggybacking off of that, my flags went all up because you're a victim of domestic violence, you live in the town in which you're a perpetrator, a law enforcement officer. Going to that station is almost never an option for them. So to kind of make this, unless they get somebody else to go in the station and raise that red flag to other law enforcement, that's really not an option for them. So my question is, I know it's handled differently in each station, but why is it that you can only go to their...
Totally understand your concern. It's what the statute itself says. So we're constrained.
reason or explanation as to why we're doing that?
I'm not a legislature.
Okay, no,
Yeah, that's from the statute. We understand the concern, absolutely. We feel bound by what the statute says. Answer.
Claudia, just to really address that, because it's an internal affairs investigation against the officer, it has to be reported to their internal affairs department, so the investigation can continue. That's the real issue with that. And then also here, Mercer, just to follow up, we've instructed the police departments that we've instructed the police departments just today that if they are seizing weapons from the lawful owner, not if, when they seize weapons from a lawful owner, that individual come with them with some proof that they can safely store them, whether it's a safe, whether it's some kind of locking mechanism. If not, we are providing firearm locks to those owners when they come in to claim the weapon. But we want to make sure that they're going to be secured. Thanks.
Thank you. Yes.
Getting back to the law enforcement officer again, which I've seen be a big concern. If I'm going against my husband, say, as law enforcement, can I go to the municipal court and have them be the petitioner rather than my going myself, or I have to go to the station?
Have to go to the station, yes.
And again, we're bound by the language of the statute.
Yes.
To add what Ann said, just to be clear for the DV victims, we're talking about people that are working with DV victims, the TRO is still in place for you to get, which means you don't have to go to the municipality if you're talking about a wife, a girlfriend, or whoever your victim is that you're dealing with, and they feel threatened by their husband who is a law enforcement agency. This isn't taking away your temporary restraining order. So you can still go to the court, get that temporary restraining order, and IA will still take place and everything will roll. So this is a little bit different. That gives you extra security, but it doesn't mean if that applies for the TRO, you should still follow that process. Because you do not have to go to the municipality. You know what I mean? I just want to make sure.
Good point. Yeah, thank you.
that I understand. I was just...
Yeah, no, but it's a very good point for all of us to remember. This is just an additional tool. It does not replace anything that went on before September 1st.
For something who's not reporting one out of officer, but just a regular, everyday person, they're going to the image office of the superior court, like so the civil court building.
So it's so the question is, where do they go? It's criminal division. So find the criminal window. Yeah, and I'm sure when you walk into the courts, they can direct you that way, but it's criminal, right? So again, that's something to keep in mind. If there's going to be a DV or restraining order applied for at the same time, it's two different windows. Family for DV, criminal for, yeah.
But you can also go to your law enforcement agency. You're not stuck just going to the court.
Another question? Well, Jeff and I will be here afterward, along with Jennifer Schoenrod and Prosecutor Onofri. If any questions we may answer for you, please let us know. We're happy to give you our information, our cards. We thank you so much for coming today. You know what? And 224. Okay. Let's